How does the FCRA impact your employment background check rights? Imagine applying for your dream job and wondering what checks are happening behind the scenes. The Fair Credit Reporting Act, or FCRA, is the law that makes sure your rights are protected during background checks. It's designed to keep the process fair and transparent for job applicants and employees alike. When employers want to look into your credit history, criminal records, or verify your past jobs and education, the FCRA sets the rules they must follow. First, employers must give you a clear written notice that a background check will be done. This notice has to be separate from your job application and easy to understand. They also need your written permission before requesting any report. This means you sign a form that explicitly states you agree to the background check. It's all about making sure you know what's happening and agree to it. The law also limits what information can be collected. Employers can look into credit reports, criminal records, employment history, education verification, and even character references. But they must tell you exactly what types of reports they plan to get. If they find something in the report that could affect your chances of getting the job, they have to follow specific steps before making a final decision. If they decide not to hire you or to fire you based on the report, they must give you a pre-adverse action notice first. This notice includes a copy of the report and a summary of your rights under the FCRA. After they make the decision, they must send a final adverse action notice explaining what happened. This process helps you understand and challenge any incorrect information. You have the right to dispute any errors in your report. If you see something wrong, you can ask the reporting agency to investigate and correct it. The agency must look into your dispute and fix any mistakes they find. This protects you from unfair decisions based on inaccurate data. It's important to note that the FCRA only applies when third-party agencies are used. If a company does its own background check internally, the law doesn't cover that process. But other laws might still protect your privacy and fairness. Employers also need to follow anti-discrimination laws, so they cannot use background checks to unfairly exclude someone based on race, age, sex, disability, or other protected traits. This helps make sure the process is fair for everyone. In the hiring and onboarding stages, employers should always give clear disclosures, get your written consent, use reputable agencies, and notify you if adverse actions are coming. They should also let you review your report and dispute any errors. Keeping good records of these steps helps everyone stay compliant and fair. So, the FCRA is there to balance the employer's need for information with your right to privacy, accuracy, and fairness. It makes sure background checks are done properly and that you're treated fairly throughout the employment process.